My name is David Hooper. I'm an English lawyer, a barrister, and for the past 25 years, I've specialized in criminal law, international law cases, crimes against humanity, war crimes, genocide. And I've done so as defense counsel at the United Nations Tribunal Courts for Rwanda and Yugoslavia, and also at the International Criminal Court. Now, this talk forms part of a project by the International Bar Association, where a number of lawyers with experience of working as defense counsel or as counsel in international courts will try to bring that experience to help you in trying war crimes in Ukraine. I think it's worth saying right at the outset that there's nothing significantly different between war crimes and other kinds of domestic crimes. If in fact you have experience of being defense advocates in the context of your own practice in Ukraine, then I'm quite sure that you will bring that experience effectively to represent people charged with war crimes. It's not a different species, in other words, of law. It's really an extension of criminal practice, if I can put it like that. Now, this talk isn't about war crimes. This talk is not about doing an international case as such, though you should not exclude it, because there is quite clearly the possibility of other courts having jurisdiction over war crimes committed by the Russian Federation. We know that the International Criminal Court is investigating cases, and indeed that Ukraine, of course, has accepted its jurisdiction, exposing, of course, its own nationals to that jurisdiction. There's a possibility, however faint it may be, that some form of international court will be established, whether that court is a hybrid court or otherwise. And there's also the possibility that other national courts will assert universal jurisdiction over an individual that falls within its jurisdiction, as Germany has done in another area. But as far as international practice is concerned, I can't recommend more highly this particular book, which I referred to before in a talk. It's called Defense Perspectives on International Criminal Justice, published by Cambridge University Press, and is a collection of essays by a number of counsel and lawyers, and deals with the obligations, duties, and difficulties that confront the defense counsel at international courts. Now, the Ukraine code, as you know, sets out its jurisdiction for war crimes in Article 438, violation of the rules of warfare. I'm not going to comment on that article specifically. It may be that other colleagues will. It's, to my mind, a rather odd section, an odd expression of the position, in as much as it goes from the very specific nominating cruel treatment of prisoners, deportation of civilian population, pillage, to the very general, where it expresses jurisdiction as any other violation of rules of warfare, etc. So it goes from the very specific to the very general. And though I know, of course, that Ukraine has adopted the ICC jurisdiction, it's not internalized the statute by further legislation, so far as I know. And it's unclear to me to what extent the crimes set out in the Rome Statute, or indeed in customary law, are specifically adopted. Now, my role as defense counsel will have been a very different experience in comparison to your own role acting as defense counsel in a Ukraine court. Firstly, I've not had to represent someone accused with war crimes against my own people, my own country, in what is clearly, as we know, an existential conflict. And it's likely to add another dimension or difficulty to the role that you have as defense counsel, whether that's on a personal level, you having to justify defending, for example, such people to friends and family, or receiving personal attacks for doing so. Though my understanding is that those among you who have represented Russian soldiers, for example, haven't met that particular problem, or whether it's a difficulty at a functional level and having difficulty, for example, in obtaining the cooperation of institutions and potential witnesses, not to mention, of course, the possible prejudice that may come in one way or another from those who try the cases. But we know that fair trial is essential in a democratic, law-based system. And there's no possibility of a fair trial without the accused being fully represented and advised by an independent and effective counsel. I'd say that our role in these cases is perhaps simply expressed as being that it's to ensure that only the guilty are convicted. So that's one difference. The second difference is that international courts, where I functioned, with perhaps the exception of the Cambodian tribunal, but all otherwise international courts dealing with war crimes and the like are clearly based on an adversarial system as opposed to the inquisitorial system. You know, well, in brief, that the adversarial model has two sides, the prosecution and the defense, equal in theory, and presenting, if the defense do present evidence, presenting their evidence to the court. And the court then decides whether the prosecution, in the light of all that evidence, has proved its case. And the judges themselves, the fact finders, do not, in an adversarial system, play any role, certainly no meaningful role, in investigating the case. Very, very different to the inquisitorial system. Now, within that adversarial system, the role of the defense is crucial. One can't imagine an adversarial system without an effective defense, because only the defense are in a position to ensure that the prosecution evidence is correct and tested, views that they represent is protected. Nobody else is going to discharge that function. So defense counsel in the courts in which I practice have had a real role, not a nominal role, a real role in the trial process. And it's not been a mere nominal role, because you can see that, for example, in half the cases that I've been defense counsel, there have been acquittals, not because of some technical point, but because the prosecution evidence was shown to be insufficient, wrong, and even that it's been based on false testimony. That's not my view, that's the view of the judges who base their verdict on that kind of consideration. At the International Criminal Tribunal for former Yugoslavia, there were about 100 convicted, and there were, getting on for 20, I think 18 people who were acquitted. It's an even higher acquittal rate at the International Criminal Court. In fact, I think if you add it all up, there's been more acquittals than convictions at the International Criminal Court. People like President Kenyatta, as he then was, the present president of Kenya, Ruto, ex-President Bagbo, President, or at least an aspirant to be president, Jean-Pierre Bemba. These were all people who were tried and effectively acquitted. And there's been a number of other cases at the ICC whose cases weren't deemed to be sufficient even to pass the initial stages of investigation by the judges. So it's been, so defense counsel do have a real role, and I think those statistics rather support the fact that it does and that it's been effective. The Ukraine Criminal Code, Article 22, states, proceedings shall be conducted on the basis of an adversarial approach. So I can see that indeed your code and practice reflects a clear move from what was once an inquisitorial system to the present more adversarial system. But my impression is that's still a work in progress. So it's probably the case that your role in a court may be somewhat more limited, I don't know to what extent, than my own has been when representing people in international tribunals. But even if that is the case, my experience and the experience of others who have worked in international courts remains highly relevant for you. After all, we all do the same job, the same law job, and the end result will often be the same. And those that we represent will doubtless face the same potential sanctions if convicted, up to life imprisonment. So my experience and that of others in this series of talks will, I think, be of interest and of help to you, because it may indicate or be a pointer to what is necessary for you as defense counsel to do your job and to be an effective defense in a domestic court, the domestic court being the focus of these talks. A third difference, of course, between my practice in international courts and what generally faces you in the Ukraine at the moment is the sheer size of the task that confronts you. My understanding is that Ukraine is generally at the moment investigating, according to the latest figures I saw, some 60,000 cases of war crimes by Russian offenders. And it's having to do so, I know, having lost up to a quarter of its courts geographically, albeit jurisdiction has been transferred, I know, and against that terrible background of war and destruction, both of people and infrastructure. So these are quite significant differences, perhaps. International courts, unfortunately, I fear, will offer little relief to that load of war crime cases. They will at best take only a tiny fraction of them. The whole Yugoslav conflict was dealt with, of course, by the Yugoslav Tribunal. The Yugoslav Tribunal, over almost 25 years, managed to complete, I think, just about 110 trials. The ICC has been getting on now 20 years, and it's managed 5 convictions. So there's an indication of a very limited international capacity. So many trials will necessarily have to take place in Ukraine, as you'd expect. All these courts, whether domestic or international, face, of course, the problem of non-cooperation by the Russian Federation, at least for the time being. Personally, I'm optimistic to this extent that in time, and it may be a long time, things will change. Things will change in Russia, and this non-cooperation may come to an end, as it did, for example, with Serbia. Meantime, how are you going to cope with all these cases? I know that Ukraine law permits trial in absentia, no accused being present. Now, it's not a procedure which I have experienced. It's not generally a permitted procedure in international courts. Though one tribunal was specifically set up, the Lebanon Tribunal, to do just that, and even had an acquittal. But as a general rule, it's not a procedure, a process of in absentia trials. Is not something you tend to find. And any court appointed lawyer, they would presumably have to be court appointed lawyers, to safeguard the interests of an absent accused, will necessarily have a very limited role. I mean, you won't have instructions. I mean, you can't even make admissions, because admission is something that has to be, of course, done by the accused. So your role in those circumstances will be limited to ensuring that the procedure is followed and only admissible evidence is admitted, and that the prosecution proves its case. Looking at contested trials, at the ICC, International Criminal Court, or at the United Nations tribunals, on average, a trial takes about 4 years, possibly longer, and certainly not shorter, or very few are shorter. That's because of the nature of the charge and the extent of the evidence that the prosecution introduces. The charges, investigations that I've seen so far that have taken place in Ukraine, I think they appear to be narrowly based. My impression is that cases that have been tried or are being conducted are charged rather analogous to domestic murder or rape cases. In any event, they're very specific crimes. The Shishi Marine case, for example, I think he was accused of killing one civilian. So it's a very limited narrative and evidence. Now, cases like that concerning a direct perpetrator, such as Shishi Marine, with limited facts, they're rarely met at international courts, where the cases are far more extensive, both in respect of the charges, the geographical extent, and the time period. And also they're commonly multi-handed, involving anything up to 5 or 6 or so accused. And they also, of course, concern people removed from the crime scene, the direct crime scene, people further up the line, the commanders, those politically in charge. And for all those reasons, the cases are often based far more on circumstantial evidence. And again, that tends to broaden the whole nature of the case. So such complex cases as they become, it goes a long way to explain the length and difficulties that confront the defense lawyer. Now, that's not to say you won't be confronted with similar problems, whether to that extent, perhaps not. A further difference in practice between international practice and your own practice is probably that in domestic cases that you will meet, you're more likely to be involved at a much earlier stage in the proceedings. You might even have to, for example, advise someone in the course of an interview and the like. And I'm not going to say very much about that because that's a fairly rare occurrence in international practice, where as a lawyer, you come into a case, you tend to come into a case at a much later stage, after the indictment indeed has been drawn up. Of course, if you are there to represent an accused in interview, then obviously you want to make sure that that accused is aware of what is going to be put to him. In other words, that the prosecution aren't in a position to, as it were, ambush him by putting particular facts to him or documents or the like, without him having some notice, so that he can give, as it were, an informed response to the questioning. Guilty pleas. There haven't been very many at the ICC. I think the Yugoslav tribunal, there were about 20 who pleaded guilty. And as with domestic systems, so with international systems, a plea of guilty, and in an appropriate case, you may have where there's the material, it may be necessary for you as counsel to advise your client not to contest the case and to seek some accommodation with the court or the prosecutor, essentially a plea bargain. A guilty plea is significant in respect of both mitigation of sentence, but also having been sentenced. There may become a time, particularly with a lengthy sentence, when there are mechanisms for review of that sentence, and an application for early release may be made, and the court's going to look at that man's behavior throughout the process, including what his attitude was to the charges of which he, by then, of course, had been convicted. So it has a significance both at the outset and at the end of any sentence. There are differences, as I said, between international practice and practice in a domestic court. But as I said, what the defense does at international courts is an indication of what the defense needs at a domestic level too. And the key is, of course, that to be effective as defense counsel, you're going to need sufficient support and assets, i.e. money. The defense role in a defense contested trial, well, this is a very brief review, but it's first of all to confront, of course, the prosecution case, obviously, the prosecution narrative, and secondly, to gather and present the evidence that the defense, if it chooses to do so, wishes to put forward. We start with the charges. It's important that the accused knows what the charge is and what the evidence is in support of those charges. The charging document has to be very clear, and it also has to refer clearly to the evidence that the prosecution claims is supportive of those allegations. This is to avoid, at least, amongst other things, the common tendency in trials, in my and others' experience, that the prosecution will sort of change its position as the trial progresses, and try and expand its case in different areas. So it's very important to ensure right from the outset that both the charging document is clear, and also that the evidence upon which the prosecution wants to rely is disclosed, and disclosed fully. The prosecution, of course, are going to disclose its case to you. It has to do so for a fair trial. And those exhibits and documents, statements, can be very extensive. But not all of it will be necessarily relevant. Some of it may be indeed inadmissible, and it's for the defense to jump on that and to object to it. Hearsay, for example, hearsay is generally admissible in international courts and in your court too. But it can be so. Start again. So hearsay, where X told me that blah blah blah, is admissible, but it can get very extenuated. And for example, in NGO reports, Human Rights Watch reports, for example, often the prosecution will like to rely on such reports, and they often contain very pointed allegations against an accused, but without any specific reference to the source. So a good test, when confronted with that kind of evidence, and you will be confronted, I'm sure, with that kind of evidence, is how prejudicial is it? And how difficult is it for the accused to confront it? Because an accused, of course, has to have the right to confront his accusers. In serving incriminating documents, of course, you're looking for exculpatory material as well. And what of the exculpatory material? Does the prosecution have a duty to seek it out? And if it comes across it, has it a duty to, in fact, provide it to you? It's very difficult in systems, I find, to rely entirely on the prosecutor to do a good job when it comes to revealing all the exculpatory material. A piece of evidence, for example, may seem highly prejudicial until it's placed in the context, the general context in which it's been taken. It will be very much for you, the defense, to chase that wider picture down. Now, many cases, for example, may involve telephonic, radio communications, intercepts, satellite imagery, for example. And the prosecution may be, because there's such an abundance of material, selective when it comes to producing its inculpatory material. You may need to access that wider material in order to see better the context, and also to see whether there are perhaps within it items that exculpate you or the accused. And there'll also be, of course, a problem when it comes to material as to the material that's in the possession of third parties. For example, intelligence reports and the like that will be held by Germany or the United States, United Kingdom, whoever. You may need to have some access to that. And your portal will necessarily have to be, that is, how do you get it? Will have to be through the judges, presumably, or directly by you approaching the relevant agency. Well, one of the problems with disclosure is that, of course, you can regret what you ask for. Also, with disclosure, of course, comes the fact that the more that's disclosed, the more work you will have to do. And much of the kind of material that becomes disclosed is very complex. And you'll need time and you'll need help to digest it, both by way of personnel, people to help you in the team, and also systems. After all, these will be electronic courts, and you'll need, in order to deal with the electronically disclosed material, necessary software to access it and to form it, case note, case track, and the like. And you'll need software. I did a case recently which involved millions of telephone communications, all cross-relating, and it needed software which wasn't available, had to be, in fact, paid for several thousand euros in order to be able to access and make sense of this enormous amount of telephonic material. Expert evidence. Well, cases often rely in some part on expert evidence. There's experts, of course, on ballistics, on trajectories, pathologists, military experts, evidence as to lines of command, experts on military law. You'll need your own expert, not only to advise you, but also possibly to give evidence and possibly to controvert the prosecution's conclusions. Investigations. International courts, as I say, are adversarial. And one of the crucial differences between an adversarial system and an inquisitorial system is that it's for the defense to present its evidence to the court. And this means that you have to go out and investigate the case. You have to visit crime scenes. You have to seek out and find witnesses and take statements and assess them as to their quality, as to whether you want to call them as witnesses. It's up to you, the accused, to decide who to call as a witness. And all of this, of course, is done in order to contradict the prosecution narrative and support your own. And when you're doing those investigations, you need to be protected. You need to be protected from arrest and interference with your investigations. You need to have your confidentiality respected. And you may need to fight for that, for your functional immunity. Witnesses for the defense may need to be protected, particularly if they may attract hostility from state authorities or other persons. But what if you can't investigate? What if the situation is such that the defense can't, for example, go to Russia and interview people there? I was involved in a case, it's an ICC case involving crimes committed in part of what was Sudan. And the Sudanese government at the time was very hostile to the ICC. And the result was that the defense couldn't do any investigations. And eventually the court stayed the proceedings, didn't stop the proceedings entirely, but stopped them until the situation could change. Of course, years have gone by. As far as I know, the situation hasn't changed. So that might, of course, be a situation you might have to argue that unless you can put forward an effective defense, that it wouldn't be a fair trial. As an advocate in trial, of course, you have both oral advocacy and also written advocacy. In the international courts, ICC and the tribunal courts, there's a mass of legal and practice issues that are resolved through written findings, admissibility of the case, challenges to the admissibility of the case, challenges to evidence, challenges to the admission or relevance of evidence, the admission of facts, general legal submissions, requests for disclosure, interlocutory appeals if there is an arrangement for that, closing submissions, representation on sentence if the man's convicted. And in an ordinary case, I say an ordinary case, in an ICC case where there is quite a high load, particularly high load of written submissions, there can be as many as 3,000 submissions by the end of a 4 or 5 year, 6 year process. So it's a lot of time, a lot of work, and a lot of law. And a lot of, I say a lot of law, there's been an immense amount of jurisprudence, both of procedure and of law, generated since 1994, when the first United Nations Tribunal was established. And these courts tend to like to see the decisions of other courts, of other judges, of seeing precedent, particularly when they obviously have been issues that are in the same or similar areas. And you can't know it all. In fact, you would need the help, undoubtedly, of legal assistants, people who are better versed in areas of law, perhaps, but also there to help you draft a lot of the written submissions and to help advise you in respect of your filings and your submissions. When it comes to looking at a defense case, in my experience, however complex a case may seem, it always really boils down, doesn't it, to one or two essential positions as far as the defense is concerned. Very simply expressed, it comes down to, I didn't do it, or perhaps a little bit more than that, I wasn't there, or others exceeded their orders, or it was lawful behavior. Whatever it might be, there's often just really a very small key position to help guide you through the morass of material that's presented to you, and helps you, that defense narrative helps guide your way, is the light at the end of the tunnel, really, with following the difficult path, as it might be, through the evidence. Oral advocacy, of course, these are courts where international courts, for all the written material that and motions that exist, like to hear all the evidence orally, like to hear from the witness, the key witnesses, and see them tested. This isn't the time or place for a lecture on cross-examining witnesses. Cross-examination undoubtedly is a skill, but the more you do, the better you get at it, is really, I think, the best, easiest thing to say about it. There's no point, obviously, in questioning for the sake of it. Some prosecution witnesses can have useful material for the defense. You may want to elicit matters that assist the accused, and of course contradict aspects of the prosecution narrative. You're going to have to assess what witnesses you want to call or have called, that the prosecution may or may not wish to have called. But with witnesses who have real bite, who really point their finger at the accused that you represent and implicate him, then you're going to have to really make up your mind whether this is a case with this particular witness, where the witness has been mistaken, for example, in identification, or if some other quality can be placed on his evidence, or whether the witness is in fact lying and misleading the court. And I think in order to question witnesses appropriately, you need to have immersed yourself in all the evidence, in the facts, in the geography of the case, and to have a very clear overview of not only what that particular witness is saying, but what all the witnesses of the prosecution have said or are going to say. And the only way you can do that is not by delegating witnesses to various people, dealing with it piecemeal like that. You have to, in my experience, to very much be in charge and be knowledgeable about all that's going on. Victims. I know that Ukraine has a definition of parties to criminal proceedings that include victims and that they can be represented by counsel. I'm unclear as to the extent of such participation. However, in international processes, victims can obviously be giving evidence on general matters, for example, because they've been affected by the crime, or they can give evidence generally about the crime scene without necessarily implicating the particular accused that you may represent. And then you get witnesses who are both victims as well as inculpating witnesses. So there's a big difference between the two. The ICE International Criminal Court is really exceptional among international courts for the heightened role, the higher role that it gives victims in the process, so that victims participate in the trial process. I'm not sure that that's a procedure that will be followed ever by any other court, because it burdens the court in time, because of the time it takes to have a multiplicity, as it were, of interests in the course of the process. But if victims do have such a participating role, then clearly they're an additional burden for the defense and require further time and resources. Time and resources. All this work needs necessary support, whether that's at representing someone at an international or a domestic level. I don't do these cases on my own. I'm provided with necessary support, a team, a case manager, legal assistance. At the International Criminal Court and the United Nations tribunals, a defense team generally comprises a lead and co-counsel, 2 or so legal assistants, a case manager necessary because of all the documents, paperwork, and the like, an investigator. This is the core team. And on top of that, of course, you've got costs of for experts. That might be an exceptional expense. You might also need help in investigations and travel. And I'd say, as a rough estimate, that comes in terms of cost to something between 30 and 50,000 euros a month. So we're talking substantial sums when you extrapolate that, not for a month, but for a year or 2 or 3 or 4 years. International justice is not cheap. But as I said at the outset, as a defense lawyer in an international context, the actual law job is the same as at the domestic level. And though there are and will be clear differences between the two, it really does, I think, stand out for me that if there is to be a fair trial in a Ukrainian court, for example, where you're representing an accused, for an effective defense, you require both competent counsel And that council needs to be supported by having sufficient assets and time and good financial support. Because you're not there just as a token. You're there very much as a necessary part of the court process. Thank you.